I'm Terrence Wilson, kdacanay over here, a couple of our attorneys with Wilson Law Group. I do a lot of these presentations now on condos, and this is the first time I've done one at the zoo, and it's the first one I've done where I got to park in the Hippo parking lot. So this is a great experience. I really like working with Blueprint. We do a lot of work with a lot of different builders from different sectors in the greater Seattle area, and I've noticed a significant difference in the Blueprint builders that we are working with. Many of you in here are working with us already. That there's an infrastructure and an intentionality built into this network where folks are constantly learning more, they have some sophistication and acumen, they bring experience to the table, and there's a sense of community in running things past one another to develop best practices and some standards that are helpful to use across the board. Even though we customize a lot of things for each of our individual builders, there's sort of a collective that rises up in terms of how most folks like to see things done. And I really appreciate this sort of fraternity that we have in here in terms of the learning that's going on. My background, for those of you who don't know, is that back in 1996, after graduating from UW, I'm a local Seattle guy, grew up here my whole life, I got a job working for my wife's father in the land surveying business. I knew nothing about real estate, and I went out in the field and realized I made a big mistake because I hate working outside throughout the different seasons. But it was my father-in-law that owned the business, and I wasn't going to let him down. So I learned about land surveying, and within a year I came into the office and started working with folks who were doing subdivisions, unit lot subdivisions, condos, and other types of permitting, and really took an interest in sort of the permitting project management side of things, how to move something from a concept or an idea on down through permitting and eventually sale. And in that process, learning about title reports and easements and boundary issues and all the kind of things that kind of go along with reviewing maps and title and projects. And then becoming an attorney, going to SU in the night while working in the survey business by day. We began to grow our law firm and adding staff. We have 11 people. They're all handpicked. Unlike the survey business that I inherited from my father-in-law, we had 30 people, most of which were there before I got there. We now have a core of people in the law firm that are all people I chose or that chose me, including Katie, who I've known since she was 5 years old, because when I was in my undergrad, I sold shoes in the mall, and she was a family that came in and I sold shoes to them. So we have a lot of love and affection and continuity in our firm because we believe in what we're doing and the people that we're working with. So it's really special, and it's special for me to be here. And I appreciate being able to speak on this topic because since '96, I've worked on a lot of different kinds of projects, from short plats and plats to condos, unit subdivisions, learning the different language and the different ways in which these projects maneuver. And I feel like what we're facing right now, if we zoom out from how busy we are and all that's going on with these developments, this product in particular, the ADU DADU condo, is one of the most unique and special kinds of products that I've ever seen in the 26 years that I've been doing work in this industry. And I say that because usually over the years when I'm working in Seattle or King County or other jurisdictions, there's pushback on whatever we're trying to do, it seems like. You know, if you're trying to get a permit, that it feels like you're fighting an uphill battle. Planners, reviewers, engineers, surveyors, everybody seemingly pushing back on what you're doing, and it feels really difficult to get anything done. I'm finding in these presentations that we're doing, which I'm doing with master builders and King County realtors and other types of agencies, that we're getting a very interesting kind of confluence of interest from all different sectors that are usually opposed to one another, that are behind this type of product. And I'm talking everything from getting calls from Spokane's planning director saying, we heard about what you guys are doing over in Seattle, and we just instituted in our code in Spokane 4 dwelling units on every single family lot, but we don't know how to separate them out and find new owners for each of those, and we want to know if you'd be willing to come over and talk to builders and developers in the Spokane area. So you get cities and jurisdictions now that are saying we are promoting, not only giving the building permits for these extra dwelling units on single family lots, but promoting the condominiumization of them. Now, not every jurisdiction's behind it yet, but it's growing. We've got Kirkland and Seattle primarily leading the way, and then we've got some other jurisdictions that are coming behind and changing their regulations and rules to allow this to be a more streamlined process. But it's an interesting thing when you look at sort of retirement planning for people that have been in a home or community for a long time, and they're looking how to stay there or maybe downsize. The DADU ADU becomes a vehicle for people who are in the neighborhood who want to stay in the neighborhood but can't afford other options, and now they can rent their old house or rent the DADU Lenders are coming up saying, we're going to lend based on the rental value that you can get out of the DAVU, and so we're going to help you fund the construction. You've got new folks coming out of college that have a smaller salary but are wanting to live in the city. You've got environmentalists that are saying, we don't like sprawl and continuing to move further out, so we like the backyard kind of stuff. And so you get all of these folks that are usually competing with one another all saying, we like this product. And then from the standpoint of jurisdictional pushback, the jurisdictions, most of them are sending condominiums our way saying, we're not involved in the review of those, so as long as we get the building permits approved and meeting our code, what you do behind the scenes to create ownership in terms of how you're going to create condo lines, which we're doing very much like a subdivision, they're saying go for it. It doesn't impact us at all. We're only looking at the building permit side of it. The ownership is a totally private matter, and the Condominium Act is set up in that way so that there is no jurisdictional oversight in terms of reviewing a condominium. In fact, there's no oversight other than the King County Assessor's Office for how a condominium, a map or declaration is going to be done. The two people that are primarily involved in creating a condominium are the surveyor and the attorney, because the surveyor makes the map and the attorney makes the declaration CC&Rs. That's what makes a condominium. And then there's a whole bunch of supporting documents that come behind it. So in 2018, there was a major change in the code in Washington State. This is across the board for any jurisdiction. It took the previous codes for subdivisions and the old Condominium Act that was in Chapter 6434, and it brought everything over into one code section. Why is that significant? On one level, because it started the process in 2018 when it came into effect of sort of erasing or minimizing at least the distinctions between the different types of communities, because the same language in the code and the same codes are affecting a plat, a short plat, a unit subdivision, a condominium. So across the board, the notion was that condos are somehow not as attractive as a fee simple short plat kind of thing, or a unit subdivision, for example. But in the end, what is turning out to reveal itself to be is that under the new code and the way that they're laid out, which is a lot of times where the condominium unit lines are like a subdivision line in that an owner owns their building and all the square footage inside that unit, but also the land around it, and the maps look very much like a unit subdivision or a subdivision map. What you're getting in the terms of a buyer feel who moves into these homes and buys these homes is that it's just like any other short plat. That's how it feels on the outside. Now there's a lot of paperwork that's involved with doing a condominium, but because there's an HOA and board members and things like that, but we're also finding that, especially in Seattle, there's a lot of non-condo projects, typical short plats, unit subdivisions, townhomes, things like that end up needing an HOA because Seattle Public Utilities requires one for a master water meter, and they're going to not allow you to have sub-meters and master water meters without an HOA. Or Seattle City Light says we're going to do a master strike and we're not going to let you have sub-meter meters for the power unless you have an HOA. Or now we're finding things like irrigation is required on certain sites to have its own meter, and they want an HOA to maintain that, or a power for a pump or something like that. And all of a sudden HOAs are needed all over the board. So whether you're talking about a condo or you're talking about a short plat or subdivision, a normal traditional one, HOAs are becoming more and more in the mix in general. But there's a difference between a project that is a subdivision with an HOA and a condominium with an HOA, even though there's a lot of similarities to them. And that's what the purpose of today is, to help you understand what is the condo need and how is that distinct, what things should you be aware of when contemplating doing a condominium. So one of the first things, I was just going to mention that when the condominium is created, and this is very important to know as to when does the condominium become a condominium? When does it actually constitute a condominium? It's two things that I mentioned: the map from the surveyor that gets recorded, and concurrent with that is the declaration of the CC&Rs. And they cross-reference to one another with recording numbers. And those two documents, even though there's a whole list of other things like a public offering statement and a budget and an HOA and a corporation and all that stuff that's also being done, those are the two primary things that when they're recorded according to the code, that's when the condo starts. That's important also to note, because some folks are coming into these kinds of projects and not aware that you have to go through that process and record those before you can sell one of the units. We sadly have 4 clients right now over this last year who have bought property, started a condominium process, either recorded the map or not, but then went and sold one of their units, maybe the older house that was already on the site that's going to become one of the 2 or 3 units, and put the legal description for the whole property in the deed. And so now it's sold with a bank loan and everything securing across the entire property. And now we got to figure out what do we do. Is if the condo map is not yet recorded, we don't even have a condo to record. Do we involve the new owners? Obviously we have to on some level because they bought the whole thing. And so there's a lot of these kinds of things, and that's going back to kind of what I had said earlier about what I like about the Blueprint family is that those are the kind of things we try to proliferate information about that. We have a constant, it's almost nauseating every day and every week we meet as a team to figure out how we can better educate and communicate with all of our clients. And that's through learning and just continually adding on new components and pieces, which now in our little narrative, we put in bold print. Do not sell the whole property. Make sure you record your condominium first. And then make sure that the legal description in your deeds with your new buyers, in your purchase agreement, and in the deed itself is all going to refer to the unit that you're creating, not to the entire former property that you had in your deed when you bought the property as a whole piece. So yeah, I think we covered everything there. We'll move to the next one. What are the condominium elements? One of the other nice things about condominiums is you can kind of pare down and really look at it as just condominiums are made up of three things. It's a unit, it's a common element, which by definition is something everybody shares, and it's a limited common element, which is something that is not shared by the whole, by everybody, something less than the whole. And that's really it. When you think about unit subdivisions and short plats and plats, we might have tracts that are owned by the HOA, or maybe a tract that's owned by the homeowner. We might have easements that are running across the property, those kinds of things. With a condominium, you might have easements that are on there that predate the condominium's creation, but when we create a new condominium project, we're just talking about a unit, a common element, and a limited common element. And so everything on the project is going to fall into one of those three categories. And so I'll go to the next slide and show you a typical example. In the city of Seattle, as many of you know, you can do up to 3 dwelling units on any one single family lot, depending on the size of the lot and so forth. We have 3 units on lots as small as 3,600 square feet. So even a pretty tiny lot can fit 3 dwelling units on it. But the fact is with the 3 units, if you're going to do 3 units, at least 2 of them have to share a party wall in some kind of connection. Now we've seen very creative connections where most of our clients like to see these projects look and feel more like a regular subdivision. So even when you have a party wall, it might be just a tiny little area around a bathroom or around a closet, just enough to say it's connected in order to meet the code. And in reality, there's going to be a line that goes through there for the unit. And in the end, it's going to feel much more like a detached kind of situation because the minimal amount of attachment is all that's required. But one of them does need to be required when you do 3. And so what you see here is kind of a typical scenario where you would have a building that has 2 units in it. Down there on the bottom, on the south side, you have a single family characterized unit and then an attached dwelling unit. And that's the AADU, attached accessory dwelling unit. Versus in the back where you have a DADU, a detached accessory dwelling unit. And we've had creative clients that have come in and maybe there's a home on the site that's 1,200 square feet or 1,000 square feet and it's already there. They'll constitute that as their DADU. They'll remodel it or recharacterize it with the city as the DADU, even though it's a pre-existing home, been there for many years. And they'll build a duplex type structure, characterize one of those units as the single family and one of them as the attached. There you get your 3 units by having a single family attached with a detached. And then as to those other areas we mentioned there, you see in the yellow, this would be an example of how a common element might be structured, where you have a pathway for walking or driving or a courtyard area that is something for everybody to be able to use. And by definition, when everybody gets to use it, it's going to be a common element. And then there'll be other features like parking, for example, where it maybe isn't for everybody to use, but it's not a part of the unit. It's either shared by more than one or it's separate from the unit, and so it's called a limited common element because it's less than the whole. It's basically a subcategory of the common element area. And so that is a typical kind of structure that we would see throughout the city when people are doing 3 units. They might be configured slightly differently, and there might be some different types of elements, but it gives you a little bit of a visual for the kinds of things we're talking about when we look at something that really, when we look at a map like that, is not what people think of when they think of condominium. People think of condominiums as being the structure and it's the internal square footage of their internal space, their ceilings, their floors, and their walls. Whereas this is being designed to have square footage of the unit be the total area of the unit, which comprises not only the structure, but it includes the yard and whatever else is around there that's part of that unit. And why that also is important to understand for builders is that when you go to sell, if your traditional mind is saying condominium is my internal square feet, and the unit on this condominium is only talking about the horizontal distance on a survey map, you need to be able to distinguish to your buyers that there's internal square footage to my structure, whether that's a 1,000 square foot attached dwelling unit or whether it's the single family home, whatever square footage it has, that's different from the unit square footage on a map that's only the horizontal area. And usually we provide a table at the end of our CC&R declarations that will say this is what the unit size is, and then within the unit is a structure, and the structure has this much square footage. So very important is to have those square footages and that data easily explainable and educatable to folks when they look at it and they go, I thought I was buying a 2,200 square foot house and it says I have a 1,300 square foot unit. How's that possible? Because it's talking about the land area. That's what the unit actually is. So what can I condo? Almost anything. Our motto, and I remember years ago when I was in law school at Seattle U, one of the guys that was known as the Condo King was Pete Middlebrooks. I think he's passed now, but an attorney that for many, many years did a lot of condos throughout the greater Puget Sound area. And he would give continuing legal education classes and say, if you can get it permitted, I can condo it. And I remember thinking, that's impossible. There's got to be some other layers of oversight, and there's got to be other considerations and zoning, and what about minimum size and setbacks, and what about walkways? They got to be 3.5 feet wide. No, condominiums are not reviewed by the jurisdiction. He ended up being mostly right at the end of the day. It really does come down to what can you get permitted. So if the jurisdiction you're working with is willing to permit it, and they're not willing to impose any specific restrictions on their permit, they can't treat a condo differently at the city just because it's a condo. In other words, the code has specific language that says whatever the city imposes on the project as a non-condo. In other words, you buy it or you build it and you just put an ADU and a dadu on there and you're going to own it all as one and rent them out or own them or whatever you're going to do. They can't then impose a different requirement on it purely because of the manner of ownership has changed. You've now put it into a condominium with separate owners. That cannot trigger a jurisdictional change. But what a jurisdiction can do, and that's why we only see these proliferating right now in places like Seattle and Kirkland, is they can put restrictions on them either way. They can say, we need you to put a covenant on here that says you cannot condominiumize this project for a certain number of years. Many of you have seen that in Seattle and other jurisdictions. Seattle removed that covenant. They also be another impediment that might be a owner occupancy covenant that says the owner of one of the dwelling units has to live here as their primary residence. Otherwise, it's in code violation. Now, to my knowledge, there's no HOA police going around checking to see who the primary owners are and whether they're living there or in Arizona, how many months of the year. 6 months is full time, is that counting on the calendar? That's not happening, but somebody could complain that it's an Airbnb and every weekend I see new people here all year long. The city could come out and they could see that the owner is not living in there, and that could be a code violation. Seattle had that. They removed it. So things like that, removing those impediments to the building permit process. Then once the permit's approved and certificate of occupancies are granted, there's no oversight at the city level. They're not going to look at this condominium map, the declaration, or any of those items. How long does it take? This is a bit of an item that I would say is probably in flux because there is a proliferation of these happening, even though I believe we're at the front end. They're still just starting. We feel like we're busy and there's a ton going on, but in reality, there's so many single family lots out there. And there's other jurisdictions coming online. So we're really at the tip of an iceberg, in my view, with momentum. And normally when you see something happening that's good in the code, grandfather lots and boundary line adjustments and all these kinds of things over the years we've seen, the pendulum swings back the other way and the codes get changed. They say, now you can't do any more than 6 lot lines, and you can't have an easement, and you can't do this, and you can't do that. Right now, the momentum is pushing forward on this. Everything is galvanizing, getting behind it, and I feel like every time I give presentations and realize how little people know about it, that even though we feel like it's been going on for 4 years and it's gone crazy, it's really the front end. So the time it takes to get it done probably will change. But right now, because I mentioned the only 2 things you need to create a condo are a survey and a declaration. It really comes down to how long does it take for the surveyor to get their work done, and how long does it take for the attorney to get their work done. Because once that work is done, then there's a timeline to get it down to the assessor, who the assessor does have to sign off on it for tax purposes, and the recorder to record it. But that's pretty minimal, and that's only a couple of weeks for that process. So the rest of it's really just on your 2 consultants in terms of how long they're going to take to get it done. Different surveyors have different approaches. Some surveyors will say, I'll give you your original boundary and topographical survey for your building permit, and then I want to come back out and I want to survey the as-built conditions. Well, the code actually says that the surveyor doesn't need to come back out unless there's an attachment that is constituting the unit line. So in the graphic I showed you where the ADU and the DADU shared a wall, that's a situation where the surveyor by code is supposed to come out and survey the actual line for the as-built conditions because the unit is based on constructed materials. But a lot of our clients right now are saying, I'm going to build a DADU in the back and I'm going to do it later. And so I want to create the condo unit line. The unit line is not going to be an as-built feature. It's just going to be a point in the ground in the backyard where I'm going to put a fence, and it's not a structure. Well, you can record that condo and show on that condo future plans if you want, or you can say no plans. You can just say it's vacant, a vacant unit. And we've had folks do that, recover or recoup the money from the old house, which is the primary part of their loan, and then go and just deal with the vacant unit in the back. Even though it's like a unit subdivision in that it's based on the overall site, we work that information into the declaration so the new homeowner on the original home understands and knows there's going to be a new structure that's built in the back, and there's an HOA and all that stuff. But technically, to answer the question, you can do all of that before you even break ground. You can do a vacant condominium unit that has a DADU built on it later, after you've even sold the other house. Okay, next one. So one of the things that comes up with every City of Seattle project, not true in Kirkland or other jurisdictions, but with Seattle it's a unique situation. How are utilities going to be handled when you're doing a condominium like this? And this is a point of a lot of confusion out there, and an evolution too. So for starters, to just narrow it all down, to help you understand that it's not nearly as big of a deal as it might sometimes feel to folks, all the other utilities outside of Seattle Public Utilities are just normally done like you would in any subdivision. You have a separate meter for gas if you're dealing with PSE, you have a separate meter for your power if you're dealing with Seattle City Light, you have separate bills for Comcast and Xfinity or whatever. You have all of that being dealt with each homeowner based on their address and based on their meter, so there's no commingling going on in the HOA or between the homeowners. But Seattle Public Utilities, they are the one that's difficult to have to get around because they send one bill for the entire development site. And that bill is going to cover the water and the sewer, and then the garbage, recycle, and yard waste, all under one umbrella. And that's one bill, and they could care less behind the scenes how you're getting that paid, as long as they get it paid. The good news is they only send that out every 2 months, so it's every 60 days. It's 6 times a year, and once you get a system down, it should only take a few minutes to do, but it warrants some discussion because how are you going to prorate it? If you have 2 units or 3 units and everybody is paying a share of a SPU bill that's covering the water, sewer, garbage, recycle, and yard waste, how is that going to be fairly distributed in terms of pro rata? And the way that it's done there's a couple of methods, but the way that it's done best is to install sub-meters. Sub-meters are not regulated in terms of being involved with SPU, but it allows the homeowner to read a meter. The meter reading, whether that's done physically by reading it like an odometer on the actual device, or whether the device is sending a signal via the internet to your phone in terms of an app or other means, or whether you hire a company like Submeter Solutions or Guardian or some of the others that will, for a fee, usually a hefty fee that most homeowners in small communities like this don't want to pay, can read the meter for you and prorate the amount and send you a statement. It says, the SPU bill was this much, your meter was this much, here's what you owe. At the end of the day, somebody still has to make the payment to SPU. So the primary ways that that's done is folks will either log in to SPU's account, either as a guest or on their actual account, and pay their share from their own source of funds, their own bank account. They'll pay that, and then as long as everybody does that, it's covered. The other way is they'll pay whatever their share is to the HOA into the HOA's bank account. And then the HOA bank account has all of the units' payments, and it makes one payment to SPU rather than each person phoning it in or going in and online and doing it. But the bottom line is you gotta make a plan. And that plan should be articulated to the buyers. Something that when buyers come into the mix, the old way before the sub-meters were getting used 3 or 4 years ago as much, was to come up with a percentage. Some of the builders like to do percentages as a cheaper, easier way instead of installing sub-meters. The problem with percentages is that you don't know how much water people are going to use. And if the dad is washing their car every day and taking showers every day, and the people in the single family are in Arizona for half the year, they're going to ask, why am I paying 70% and the daddy's paying 30% when they're using 80% of the water? And that's dictating their SPU bill. So little nuances like that are things to get familiar with. Once you understand them, it's cookie cutter. Same every project. They all work the same way. Okay, that covers that one. So one of the distinctions I mentioned earlier with regard to HOAs, a lot of projects have HOAs now. And everyone that does should have a transfer meeting, election of board members and officers, bylaws, deal with the IRS tax return once a year, deal with updating the Secretary of State's records for who the governing persons are, who the registered agent is. This is all the same no matter what kind of project you have. But a condominium has some additional layers that are important to be aware of in terms of requirements. And there's a handful of them. One of them is insurance. Insurance by code in a condo is required. In a non-condo, it's not, unless the project is of a certain size. There is a time and point in which even a regular subdivision that's 13 units or lots or more becomes a lot like a condo in that it has to have all the same full wakaiwa is what we call those ones when they're big. But every condo, 2 units even, is full wakaiwa. It needs all the stuff. And we do get some pushback from people saying, why is it that this condominium needs a 56-page declaration? CC&Rs. Why is it so much? Can't you pare this thing down to 15 pages like the CC&Rs we do on unit subdivisions? The answer is no. Because the code requires a condominium has formalities that it has to go through. It doesn't matter if it's 2 units or if it's 100 units. It's going to have these components. And the insurance is structured that it says in the code that for every condo, you have to have insurance to protect the board members from liability. If they make a mistake, commit crime or fraud, empty the bank account, there has to be a coverage in place so that the HOA can continue on. It's kind of paternal, protects the other owners from that kind of incident. And that's a requirement no matter what. So in the examples I gave in the visual are talking about how you have some condos that are just 2 units with a line, no shared features, no common elements. In those kinds of projects, that's the only insurance component you need to have. It's the protection for the board members. It runs about $100 a year when you're in that kind of scenario. If you have common elements that we talked about, walkways, parking areas, courtyards, things like that that are shared by multiple owners, then the insurance requirement for all condos, regardless of size, is that it has liability coverage for those areas because they're not part of the unit. They're a separate part, almost like a tract in a subdivision that would be treated. It's a separate entity, not part of it. So if someone breaks their ankle in the walkway, the HOA's insurance kicks in and covers the liability for damage that happens in that area. Third, if you have a shared wall, an ADU, then the code says the homeowner's insurance policy has to be covered by the HOA. Very big distinction from a normal subdivision where you can have a party wall in a townhome. Nobody's getting if you don't have an HOA, you're not getting an insurance through the HOA for those buildings. Everybody covers their own insurance. And even if you do have an HOA, they're not requiring that on smaller subdivisions. But in a condo, it doesn't even matter if it's 2 units, you share a wall, the HOA has to cover the insurance for the building. So, important to advise buyers that they don't need to get their own separate homeowner's insurance when they're buying an attached unit. What if you have 3 units and one's detached? Well, now you have another wrinkle because the detached one is not required to have insurance through the HOA. It's not sharing a party wall. So you get a premium from an insurance company that says, here's your total bill. It's going to include the officer's protection that's required. It's going to include the common element areas that's required. And then it's going to have a number that is the homeowner's insurance component, and we pull that out and when we do the dues, and we don't impose that part on the homeowner that's detached because they're going to get their own homeowner's insurance. And the ones that are connected are going to be covered through the HOA. So there's some prorating that goes on in breaking down the fees for the insurance. Once again, as complicated as that all sounds, you get that dialed in, and then every single project that has an attached dwelling unit is the exact same way. You now have a model and a method, and you can educate yourself and your buyers and help everybody understand this is how it's done. We have an average of 1 HOA transfer a day right now, and it's starting to ramp up. We're having oftentimes 2 a day. That's just a matter of backlog of how many have been recorded and required in the process. And with new homeowners that represent age groups from everybody down into their late teens all the way up to retirement age, with little to no experience in ever dealing with all this stuff, in 1 hour we can cover all this stuff and get very few questions afterwards. It's a set it and forget it once it's been explained. Everybody seems to come to an understanding, and we've seen it across the board. So it's on the front end, if you've never been exposed to stuff, it seems like a lot, but at the end of the day, it really isn't. It's just a matter of going down the list and filling in all the blanks, and then having that same process every time so that you're always covering the basics. So in the budgeting of these projects, yes, okay, we have an HOA, and we have insurance requirements for every condo. Every WAU condo has that. And then we also have a Secretary of State every year will ping you for $10. They want an annual renewal of who the governing persons are, who are the board members of this HOA. So in our process of transferring over the HOA to new homeowners, will have originally set it up with whoever the builder is, as usually the initial governing person or a representative from their firm. And then in the HOA transfer meeting, we elect board members and officers, and then we go online and we change the governing persons to the new homeowners. And then once a year, from that point forward, based on the date that the corporation for the HOA was set up, they'll get a $10 annual renewal. And at that point, they can change board members and make notes of any changes to the registered agent. But that is a budgetary item that's in every single project. It's $10. The $10 fee and the insurance are really the only two things that are required to be in the budget for these ADU DABI projects. So it is a budget, it is a bank account, it is planning, but once we set it up originally, unless there's a change, there's really no need to have to go back and retweak that unless the insurance price changes or the Secretary of State fee changes, or they decide, hey, we want to do some other things in the budget that are not required, like landscaping or window washing or snow plow removal or whatever maybe they want to put through there that's not a requirement, but maybe they want to do it. But those are the things you would put into a budget, and then that becomes the annual budget broken into what each person needs to pay either monthly, quarterly, biannually, or annually. And we usually tell folks, because you're talking about sometimes a $100 insurance fee and a $10 annual renewal being split 2 ways or 3 ways, just pay the whole thing up front, and then you don't have dues every month. You just pay it once a year. And again, you're back down to this is a 5 to 10 minute exercise for them every year to deal with. And it doesn't take long, and all the complications we've talked about become rear view mirror, sitting there in their Dropbox somewhere if they ever need to pull it out or when they go to sell their units. So there are a handful of other documents, some that are recorded and some that are not. So recorded documents for a condo, I've mentioned, are the survey map and the declaration. They dovetail to one another, and refer to one another, and cross-reference one another. But there's a whole bunch of other documentation, a lot of which is not recorded. This is also why it's important to have an electronic storage system, which we always set up for our clients and the homeowners just on a Google Drive. They don't have to keep it that way, but at least there's a spot where everything can come in one email rather than trying to go to escrow or to the builder or figure out piecemeal where everything is. But some of those other items are a public offering statement. Every condo, whether 2 units or 100 units, requires a public offering statement. What's a public offering statement? Just a list of governing documents that the new homeowner has to be given. What's important for builders to understand is that that list has to be entirely filled out and provided to a buyer, and by code, they have 7 days to rescind their contract. That's a very significant thing in this market, because if somebody decides, oh no, I'm having cold feet, I don't want to buy, they can cite anything in that public offering statement and say, I'm bailing 7 days later. Even if there's no other place that says they have 7 days, essentially a contingency, they have 7 days by code to back out. And they can back out for any reason or no reason based on that. Now, if you haven't given them a public offering statement, you haven't started the 7 days. So important to give them the public offering statement right up front when they sign the purchase agreement. Even if you're doing a pre-sale purchase agreement and it's not a recorded condo yet, the public offering statement can be drafts. As long as the drafts are not significantly and materially changing between the time you provide them to your buyer and the time they actually close, that doesn't matter that later you got them recorded or even made small little tweaks. They've been given the public offering statement, it hasn't materially changed, and they've had their 7 days, and now that thing can kind of check that off the list. But important to know those kinds of details. So the other thing about condos, different from all other types of subdivisions, is an imposed 4-year limited warranty quality. A lot of people don't know about that, or they've heard horror stories about the old condos that used to have a whole network of attorneys and project management companies and insurance folks and all kinds of people in cahoots, basically going chasing down 5-10 years later where there's a window problem or a roof problem, and then filing kind of like a class action lawsuit basically against builders and developers who have long since moved away onto other projects, and now they're worried about this liability hanging out there forever. A lot of things have been tightened up over the last 4 years since the new code went into effect. One of which is the definition of when the 4 years starts is no longer when the owner finds out about the problem or some other type of statute of repose issue. It's 4 years from the time of the deed. It's very clear in Wakaiwa, which is the 6490 RCW, that at the time of the conveyance of the unit, when the person closes and records their deed, that's the time the 4-year period starts. What's included in the 4-year warranty? We haven't seen any litigation that I know of in the last 4 years on these yet, but it applies to all the systems, major systems of the house, roofing, electrical, plumbing, things like that. So a lot of folks ask, well, what about my 1-year warranty, or I do a 210 through another company and that sort of thing? That's fine. That's what you provide your client. You don't need to Tell them, and you have another 4-year thing that's in the code automatically that you can go in and use anytime you want. Don't even talk about that. You don't need it. It's in the code. Go read 156 page, what chapter 6490, and if they come across it, they come across it. Now, if they hire an attorney and the attorney's savvy, they'll be able to tell them. So folks ask, well, what if, a lot of these condominiums that we're doing have an old home? There's an old home on there, and that old home, they have really outdated electrical, really outdated roofing. And buyer beware, they know they're getting it as is. Now, do I have a 4-year warranty on that old house? It might be a 1910 built house. Yes, you have a 4-year warranty on a condominium unit based on when the condominium was created. It doesn't matter how old the home is. The home can be very old, but the home was not a condo until you made it one. When you make it a condo by recording a map and recording a declaration, you now have a condominium unit, and the code imposes a 4-year warranty. Now, the code allows you to carve out specific areas that you're not going to warranty under that, and you can have the buyer sign that. It kind of cuts both ways, because the moment you say, hey, there's some issues with the roofing, and we're not going to warranty it at all, you're taking it as is, and you need to sign this purchase and sale agreement addendum that says so. Now you've alerted them that there's a problem with the roof. So it's one of those things you have to decide, is it worth it to just have everybody on the same page, knowing we're all agreeing that you're buying this home for this price based on its condition, and you know what you're inheriting, and if you have agreement in that, you can do that. Now, can you exempt the whole system, like the entire roof? I called up Josh Rosenstein, who's one of the attorneys who authored the code, and I said, what are your thoughts on this? The code says that you can exempt out certain areas if you do it by agreement. He goes, the code wasn't intended to be blanket exemptions, like all the roofing might be bad, all the electrical might be bad. He goes, you would do better to insulate yourself from litigation by being specific. The part of the roof that's on the north side of the house in that area, maybe give it a dimension or whatever, or the part of the plumbing in the master bathroom. We all know that's old and might fail. Be specific when you can, rather than trying to say, everything in this house and the roofing that ever goes bad is not going to be covered. Maybe that flies, maybe it doesn't. I haven't seen the litigation on it, but to be safe, I would be specific that you have that way of dealing with the old house that happens to be one of your condo units. Let's see here. I think I covered everything on that. There's a lot of other little nuances that we have found over time are helpful to be aware of when selling condos. Some of these things are similar when you do a subdivision, because when you do a subdivision or a condo, the property taxes will be assessed at some time in the future, right? You record a map and a declaration, and it doesn't automatically suddenly give you 2 parcel numbers. Now you have legal descriptions, and you can sell the property, but it's going to have 1 tax account number based on the overall parent parcel that was being condominiumized. And the way that breaks down is that for the first 6 months of the year, this is generally, I just found out this morning from one of our clients that had a map recorded in January that they already have their parcel numbers now, and it's not the end of the year yet. But the general rule is you should be mindful that they're in the first, essentially 6 months of the year, first half, that when you record a condominium, that because it's in the first half of the year, that by the time the following year comes around, the assessor's office should have 2 new parcel numbers or 3 new parcel numbers or however many are in your condo, and new valuations and tax bills that will go to that individual unit owner the following year. Nothing for the rest of that year that you're in right now. That'll be under 1 parcel number and whatever value it is. And if you do it in the second half of the year, after the June roughly cutoff, it won't be updated until the following year after the next. In other words, if we did something right now that we recorded, it's not going to even have a tax roll change potentially until 2024. Why is that important is that we've had builders who have been, that buyers have threatened to sue the builders for taxes because they're getting 1 bill for however long that period is, the rest of this year or all of next year, depending on when it records, and no way of breaking it down to understand who pays what. And it usually goes to the primary residence address. So sometimes that primary residence is getting it and saying, I shouldn't have to pay for what has improvements on it. The value's gone up to include the DADU and the ADU. And now I'm being imposed because there's no new legal description, no new parcel number that's on the tax rolls. So I'm getting an assessor's valuation and bill, and I shouldn't have to pay the whole thing. So then they go after the DADU owner or the ADU owner, and the ADU DADU owner's going, I don't see my name on there, I don't see my tax parcel number on there. And then you get into this finger pointing, and then somebody goes back to the builder. Well, you should. So we've come up with some language. You can specify in the public offering statement is one place where we can put this. The other is you can put it in your purchase agreement. But basically just says, listen, we can't control when the tax assessor is going to get around to valuing your property and giving you your own parcel number. But what we can do is tell you when you get the bill, it's not our responsibility. You pay taxes from the time you close forward, like traditionally, And secondly, as between the owners, we'll help you by providing you a breakdown based on square footages or however you want to do it, but then that can be a contractual obligation that folks are assuming. And even if they don't have that in there, most people intuitively would say, I know I need to pay some share of the taxes when it comes if my improvements are on that bill, even if we don't have a tax account number. But these are the little things that you don't learn about until you're in that situation and things come up. So I want to show a couple different examples of what I've been referring to. On the left-hand side here, you'll see the design I talked about, which is kind of the preferred design for folks when it has no common elements, therefore the insurance is cheaper, there's less to interact with in the owners. It's more like a normal subdivision. You just got one line in the backyard. Corner lots are real big on this. They'll have one corner lot going one way and the other going the other. There's just no interaction, and it really creates the most minimalistic kind of condo approach. The one in the middle, real common as well, kind of like the first diagram I showed where you have 3 units, so 2 have to be attached, and so we're going to not be able to get away from the fact that we have a common line going through a wall. But it's still got land for the primary front and backyards. It's still got land around the other 2 units, but it has some common elements like walkways, parking, bike storage, things like that might be involved. And then you have more traditional detached thing. You'll see some of these in the RSL zones where they're doing multiple single families and multiple detached, and it kind of looks more like a little plat that's got, or a short plat that's got detached buildings, but it might still have limited and common element walkways. We've developed, sometimes when we send our documents out, we get the comments, oh, there's all these documents, all these things to fill out. We've created, from all the years we've worked on subdivisions and unit subdivisions and short plats and plats, kind of an understanding of what is it normally that a jurisdiction would look at when you're doing a subdivision. Because even though we're not putting this through the jurisdictional review, it's probably important for you to think about pedestrian access, parking, where's my garbage going to go? During the week, is the garbage going to be stored in one place and then on pickup day it's going to be in another place? And if that's the case, do I have access rights to the other place that I'm going? Am I going to have bicycle storage? Am I going to do EV stations for electric cars? All of these things, any number of them, are not being reviewed by the jurisdiction. And you're going to carve up this thing and create new ownership that feels like a lot like a subdivision. You have to think through the design elements. Now that I'm creating these lines and creating this layout, how are these owners going to work together on stuff? So we have a checklist for every new job that a client signs up to do that walks you through. It's a 3 or 4 page checklist, and someone's like, it's so long. There's a whole bunch of stuff that you're going to be like, doesn't apply. Skip to the next page, right? I don't have a sewer pump. I don't have a storm pump. I'm not doing bike storage. I'm not doing EV stations. I'm not going to do a courtyard. I'm not going to do a picnic bench, whatever. But it's in there because you might say, oh, maybe I do want that. Maybe I do want a bicycle storage area. Or maybe we should think about where we're going to go with the parking or the walkway area. And maybe I should think about the fact that when it's pickup day, it's at a different location, but I have no rights to get to the new location without trespassing on another person's unit. So maybe I should create a walkway there. These are just the kind of considerations as you go through the checklist. It gives you a chance to think about your project, your unique project. And then, of course, as we all know, things get built in the field differently than what was the original intent. Right? That's one of the big things that we run across that creates chaos in the sale process with the new homeowners is the parking doesn't fit, the walkway's too short. Oh, the neighbor has an encroaching fence that's over and we can't actually squeeze all these elements that we showed on all of our plans. I have a project right now that went through the whole process at the City of Seattle for a 3-unit. They've already demoed the old house, getting ready to break ground, and they came to us and said, we want to start the condo process. I said, okay. And they said, oh, we got a letter from the neighbor's attorney saying that the fence is encroaching 8 feet into our property. What do we do about that? Well, your dad do an ADU or propose to be 5 feet away from the property line if that fence, which looks like it's been there for 100 years, probably has an adverse possession claim and you probably can't build it there. Well, can't we just take the fence down? That's our property, right? No. No, it's not your property. It might be your property, depending on the facts. We got to go into all that and talk to the attorney on the other side and figure all that out. Lo and behold, that fence has been there forever. It's exclusively being used on the other side by the other owner, and they've got us. They got leverage. I mean, we can move forward, but it's like we're trespassing now if we do anything else. So you can redesign the plans after the demo's done. Now the project's sitting there with all the costs sunk into it, and we're starting the plan review all over again. Work with the neighbor, try to get them to buy your property. I mean, these are the kind of things you got to think through, and so it's helpful to start at the beginning with, if people ask all the time, when should I get started on this? Start early. Start going through the checklist early. Start getting us involved early. Let's look at a title report. Do you have easements? Do you have encroachments? Usually you have a boundary and topographical survey to get your building permit, so you know about that fence. It's on your survey. And you're looking at that survey when you go to get your permit. Well, the city didn't say anything about it. They don't care. They're not involved in neighbor disputes. So you need to be aware of it because this could kill your project. That kind of stuff to think through. So those are the different kind of elements and designs. I like this picture here. One of our clients, I just couldn't believe it. It was a 36-foot wide lot by 100 feet deep. It's a postage stamp lot, is what we would call it, right? It's so tiny. They got 3 units on it. The front 2 have rooftop decks. They're 3 stories. And when you have an attachment, any kind of attachment, you get certain other architectural considerations that allow you to build taller walls. You can have non-living space that's not counted in your 1,000 square feet. So you end up having something that looks like more like a townhome development that you would see in a multifamily zone with 3 floors and a beautiful courtyard rooftop deck with a view down to the city and all this stuff, and a detached one that's in the back. On a 3,600 square foot lot with only 36 feet of width, it's amazing that you can squeeze all that in on a lot. All right, so in wrapping things up, what I would say is get started early if you're thinking about doing a condominium. Have title reports reviewed, look at easements, look at your survey data, make sure that just because it's not going to be brought up by the city, understand that condos are not reviewed by the city. So all the considerations that normally would have went into what a land use planner would have done in reviewing your subdivision needs to be done by somebody else. Whether it's us, whether it's a surveyor, whether it's you, or a combination of different consultants and people. Get going earlier on, and even if it means you prepare a bunch of draft documents that then go into a queue and sit for 3 months. That's better than starting the process when you're vertical and you're like, oh yeah, we need to get the paperwork for that condo thing done so we can sell the units, and then you run into some other issues or problems that you're not able to address at that stage without it impacting, on a much greater level. One of the things I'm going to ask Katie to comment on. So Katie, I've dubbed her the condo queen. We had a Pete Middlebrooks condo king, and you've seen in this industry, there's not a lot of representation from female professionals in the real estate development industry. I'd like to see more. And having known her since she was 5, I'm glad to have her on board, and we dub her the condo queen, because if you go and look at all the recordings of all these condos on King County Records, for example, you're going to see about 80% of them are in our firm, and they're being done by her. But we have a whole team of infrastructure around her, people that do the HOA setups and the transfer meetings and all the different things. But Katie is the one that's doing the declarations and the public offering statements and helping work through all these issues for most all of our clients that are doing them. So, but I got a call this morning, just before this meeting, someone saying, hey, you got a 56-page document here, and we've got a few of these condos now, and every once in a while we have a buyer saying, why is the declaration so big? Can't we pare this thing down like the CC&Rs are to some 15 pages or whatever? And we try to explain to them that no, you can't pare it all down, but our firm's philosophy and how to create all of these documents and all of these checklists and templates and systems is to say there is a best practice that applies to most people or most situations, and we find it across the board really helpful. But there's also unique situations for each builder, each developer, either based on their past experience or based on their knowledge of things or based on their intentions, where we want to be able to be customized as well for you based on what your needs are. But there's only so much customization you can do when you're dealing with a code that has certain requirements. And we've actually sat down with a couple of our customers to go through, or clients to go through our declaration and try to figure out how can we pare this down based on their feedback and circling areas, saying, why is this here, how's this here? And when we go to the code and we look at it, we go, these are not areas we can take out. They're required to be in there by code, and they're really in there almost verbatim based on what's in the RCW. But it doesn't mean there aren't little tweaks and things. I mean, I think we've pared it down 1 page here or 1 page there, but it's not going to take a 56-page document and make it into a 12-page document. It's never going to happen. So the other question that came up was then, well, what about a cheat sheet? Some kind of way of providing a more of a Cliff Notes version of that. And so I want to give Katie a chance to ask a questionnaire on that, but also to introduce herself and offer any other feedback that she has in light of all that we've been sharing.
Hi guys. As Terry mentioned, we had a client ask this morning about a cheat sheet, and it's a question that's been posed to me before. Sometimes agents prepare them for buyers and frequently send them to me for review, which is helpful because agents are often not quite sure how the condo process works or about utilities. And so something we were just discussing is that something that those of you who have done condos think would be helpful to buyers? If our firm prepared a 1 to 2 page document that kind of broke down some basic things, and kind of what it included would depend on what you wanted. Like we could include that there's an HOA or owner responsibilities or HOA responsibilities.
One page.
One page.
One page. Listen, we got Albert. Yeah, I'll see what I can do, but I understand from a buyer perspective that it's hard because there are so many pages and we understand them fairly well because I wrote it, I read it 100 times, but I do understand that would be confusing. It will be difficult to distill down certain points into a one-page document, but it might be helpful. And so if you guys find it helpful, that's something that we can definitely work on. And then if there's certain things that you always want included or that you never want included, let me know and we can craft something specific to your project. So.
I thought it might be helpful also to talk for just a second about the fact that every one of these projects needs to do an HOA transfer. After you set these up, in order to create the condominium, you have an HOA which has bylaws, you have an EIN with the IRS, a lot of bad information out there. You set up an entity, you have to file a tax return. So if you set that up in November of last year, then this year you have to file a tax return by April 15th. Why? There's no taxes due, because that's what the code says. That's what the IRS's code says. You have to file a tax return for any entity based on its incorporation year. So there's no taxes that are due in an HOA, and there's no penalty that I'm aware of if it's late. I've stepped into some of these to help clean them up, and there's 3 years gone by and no tax returns filed, and nobody's chasing down the HOA asking for where it's at. But when you go to sell them, you offer the public offering statement, and you're giving them all these documents and governing documents, one of which is, give me the latest tax returns if there are any that were required, and you should have that information ready to go. But in the transfer meeting, we do several things. So, and this all happens within the time of an hour usually. Some of them as little as a half hour. And then for ones, you get a homeowner that has a lot of questions, they might go an hour and a half. But realistically, they're anywhere from half an hour to an hour on average, and occasionally when there's somebody that wants to get in the weeds, a little longer. But that's all it takes, even for the most kind of detail-oriented new buyer that says, I was in an HOA in New York, we had 300 people, and I know all these things. Even in that, we can usually get it pared down with an hour, hour and a half, and get them on their way. But there are some important critical things that need to happen. One is, after you've sold the units, you're required to have that HOA transfer meeting, I think it's within 60 days, or at least a notice go out. So you need to be prepared to create a roster to give to us or whoever's going to do the HOA transfer meeting so that we can be in coordinating dates and schedules of availability. We want to have the right quorum and participation. Even more important than the quorum is just that all the homeowners know that if I come to this meeting, I'll at least be there and have a say in how things are going. And in that meeting, we're going to elect board members and officers. They're usually the same people. Board members are the managers of the HOA, but then there's officers, which are more like your title or your role that you're playing in an HOA. There's a president, a secretary, and a treasurer. And the president's going to lead the meetings and be the point person. The secretary is going to take the notes and make sure that Dropbox or Google Drive that we've set up has all the electronic documents that are needed. And the treasurer is going to balance the checkbook and hopefully make sure that tax return gets filed every year. But there's a lot of transferring of information over that needs to be discussed in these situations so that you don't have the builder's name that was used to set up all the accounts still sitting on there at the IRS or at the Secretary of State or with the insurance provider or the HOA with the SPU. All these things are things that have to be transferred in addition to electing board members and officers. So we cover all of that stuff, and the way we've structured it is to try to make it as minimal and least involved for everybody as possible. So we have these meetings and we elect the board members and we make a plan for all these things, and we usually do it all behind the scenes within a couple hours or less over the next few weeks after that meeting has occurred, so that all the records are updated with the IRS, the records are updated with the Secretary of State. The new owners have a packet of information that includes the minutes from the meeting as well as all the other governing documents in one location. And then we talk about bank accounts and budgets. Bank accounts are something that are oftentimes not set up ahead of time, and that's fine. Most of our clients now don't. We usually have money, and this is another source of confusion that's worth mentioning, that for all these projects there needs to be some consideration about whether or not there's going to be some money given to the HOA at the time of the transfer. Either by the developer, who's going to put some money as sort of seed money in there so they don't transfer it over and get their insurance bill 2 months later and they have to take up a special assessment in order to cover that cost because there's no money in the bank account. But more commonly what's done now is not so much having the builder or the developer put a deposit in, but usually what it is that there's an instruction to take out an initial capital contribution from escrow. That money comes out of the buyer's pocket, but it's at least money that escrow has set aside. Now the issue is, I mentioned we have a 56-page document, and that's buried on like page 49, based on what the developer asks us to do. So a typical amount might be like $200 or $250, and each homeowner is supposed to have that money taken out. Well, we also find that in this process, one of the things that happens is as people are getting their loans and getting ready to close on this, we'll get contacted by the lender saying, I need you to fill out this checklist for us so we know how to handle our escrow processes with the lending group. And they might have their own rule about, we want 3 months dues set aside. And so now you have this little weird 2 or 3 month dues that got pulled out, and then you have maybe an initial capital contribution that was instructed in the declaration that everybody was supposed to put in there. And then you have the fact that escrow might not know about any of this stuff. And nobody told them that on page 49 there's initial capital contribution that needs to be taken out. So maybe you have one owner where that got caught and they put the $250 in there, and then another owner's like, I didn't put anything in there. So it's good, to, first of all, to have a plan. Do you want there to be an initial capital contribution? I recommend you do, and that way you're not putting the money in as the builder, but the buyer's own money is going into an account that is allowing them to set it up originally when the transfer is done with some money in there. Now the fact that there's no bank account yet set up just means that that money is either at escrow or got sent back to you as the builder, and it's in a check in the name of the HOA. And while you're in control of the HOA as the builder or the declarant that's originally developing the property, the transfer after the meeting that we have will elect the new board members, and then you just give them the check, or you can go deposit it in the account that they select. But the new buyers will set up the bank account typically based on convenience to where they live, and hopefully finding a product that's free. Not all banks charge, some banks charge a fee for these small HOAs because there's a very limited balance and a limited amount of checks that are getting written, and as a result they don't have a free product. But a lot of the local banks and credit unions do, and we cover all that and let the buyers decide how they want to proceed with that. But it's important for you guys to know, as builders and developers, where the instructions are in terms of whether you want money to be set aside at a closing, and then if you do, since we're not always involved with the escrow and the closing of these units, somebody on the builder side's team needs to communicate to escrow that on page 49 there is a instruction to put the money in there for that, so that there's a plan in place and everybody can be squared up when we do the transfer meeting. So in the transfer meeting we cover board members and officers. We then cover the new registered agent, so that all the mail that comes from the Secretary of State no longer goes to you as the developer, but it goes to whoever's volunteered to serve in that role, usually one of the board members. It's only 2 or 3 people anyway. And so all the records get updated at the Secretary of State level on our end. So the builder doesn't do anything, the new homeowners don't do anything, they just get a packet and it's all set in place, and then they don't have to take any more action until the annual renewal comes up. We also update the IRS. We just had a big property management company that does large condos and large plats throughout the city, and they said, we've never had to update the IRS records. Why are you telling us you have to update the IRS records? When you get an EIN, a person's name and social security number is given to the IRS as the responsible party. It's right on their website, it's laid out in code. You cannot use an LLC or an entity. It has to be a person and a social security number. And I guess there's probably hundreds of people out there that were part of the developer team that are on HOAs right now as the responsible party for all these HOAs out there, because people aren't going through a process of changing that. There's a form, and we elect that person in the transfer meeting that's usually one of the board members that's going to say, I will be the responsible party. We give them the form, we leave their social security number blank, and they fill it in and send it off. And that's one of the only action items that they have to take after the transfer meeting, is whoever's electing to do that. That updates the IRS records. So you have your Secretary of State, your IRS records being updated, banks and bank accounts and budgets are discussed, and then the SPU and utility kind of arrangements discussed along with some other miscellaneous items, and that's the totality of the transfer. And that really covers everything needed. So as much of a mountain of information as all this sounds, it can really be pared down into a bit of a science that you can just duplicate and replicate once you're familiar with the various terms. So that covers our general presentation on condos, what they are, how they're created, what's involved in them. I wanted to give some space here at the end for questions for the whole group, and I'll just take those and maybe just pass out the mic. Here's a wireless. And then I also want everybody to know that if your questions don't get answered right now, I'm going to go into the back and hang out as long as anybody wants to hang out and talk about this stuff. And then after that, if there's more questions, just email me or call me.